Assalamualaikum and good afternoon, students.
Afternoon,
Hello,
madam.
students.
Afternoon, madam.
Afternoon.
Yeah, okay, good. Okay. So I know it's already Thursday, coming towards the end of the week. Okay. Maybe some of you all a bit tired preparing for the class, but no mind. Tomorrow you will have rest. Friday is a rest day. Okay. So we have a class today on managerial prerogative. Okay. That means the powers of the management. Okay. So for today's class, I will introduce what are the powers of the management. Okay, so you will study in this topic. Okay, so are everybody ready for the class?
Yes,
Yes.
madam.
Yes, madam.
Okay, thank you. So we'll start the class. Okay, managerial prerogative. Okay, maybe you have heard before. Okay, so it is the management right. Okay, so management right is recognized under the law. So we have a special provision for that. That's under Section 13 of the Industrial Relation Act. IRA is the Industrial Relation Act. Okay. So it's section 13, subsection 3. So when you answer the exam question, make sure that you put the correct section. That means it's very specific. It's not just like section 13. So you have the section 13 and the next to it, we call it subsection. Okay, subsection 3. Okay, section 13, subsection 3. So this section talk about prerogative of management. First, we look at the promotion. Okay, because it is like ABC, so I have to go in order. Okay, A is on promotion by an employer of a workman. Okay, from lower grade or category to a higher grade or category. That means if the employer want to promote an employee or workman, okay, so it's within the manager prerogative. And you know the Employment Act use the word employee and the Industrial Relation Act use the word workman. Okay, so in this section you will see the word workman. Okay, so we go in detail afterwards. Okay, so we look at the section first. So the second one is about transfer. If an employer want to transfer workman from the organization, okay, he also have the power. Okay, the employer's power to transfer an employee from the organization of employer's profession, business, trade, or work. And it's about the employment. Okay, if there's any vacancy, the employer may appoint any person that in the event of vacancy. Okay, so if there's any vacancy, so the employer's power to appoint anyone. Then it's about termination. Okay, so termination by an employer of the service of a workman. Okay, so if the employer wants to terminate an employee in case of redundancy, is also the employer's prerogative. Okay, and dismissal also the employer's prerogative together with the assignment or allocation by an employee of duty or specific task. So everything is employer's right or prerogative. Okay, like employment in case of vacancy, termination, dismissal, assignment of work to do. Okay, so it's all stated under section 13, subsection A. Yeah? Okay, A, B, C, D, E, F. Okay, so you can put in the notes or you can write down in your own notebook regarding extra information given by the lecturer regarding certain topics. Okay, then all these cases, since we are using Dunson Idura as a main reference, so these cases has been discussed in Dunson Idura. So you can see how the judge give the quotation. So it's a quotation if it is like this. Okay, so all Malayan Estate Staff Union and Malayan Agricultural Producers Association. Okay, this is the number of the award, or we call this as citation, Award 120/1978. So in this case, the court says that time and again, the court here and the Commonwealth have held that manager prerogative are not absolute. So the management rights is not absolute. That means it's not 100% belongs to the manager. Okay, so it's there's some limit for that. Okay, so the court says when it is shown that the exercise of this prerogative is not bona fide, that means there's ill intention or amounts to unfair labour practice, the industrial court will not hesitate to strike down such exercise aspect. So the employer here must use the powers and the prerogative they have or given by the law according to law. Okay, they cannot have ill intention or they cannot do something which is unfair labour practice. Okay, because if the matter goes to the court, the industrial court will not hesitate. That means will strike down the exercise of such power aspect. Okay, so this is the rule on manager prerogative. Even though the section 13 subsection 3 gives a prerogative to the management, but there's some limit for that. It's not absolute. Okay, so we start again. But we cannot go direct into the session because normally when a workman is appointed or an employee is appointed, normally there will be placement, okay, which we call penempatan in Bahasa Malaysia. Okay, so the industrial court on this matter take the view that any matter connected with the job, such as job design. So when you're appointed, you are given job design or job content or job description or job specification, or it is called sometimes job analysis or job evaluation or job grading, is all very much a managerial prerogative. Okay, so all this matter that I mentioned now is the managerial prerogative. Okay, so the exercise of the prerogative can be challenged. However, if you want to challenge the managerial prerogative, you can. Okay, and it can be a subject matter of a trade dispute. Okay, so there will be a dispute between the workman and the employer. Okay, so the prerogative can be challenged. If you are not satisfied, okay, your job content is not same as given in the letter of appointment, so you can challenge in the court. So it doesn't matter, okay, even though the prerogative is belongs to the management, you can still challenge it at the court. Okay, so when you are appointed, okay, or you are given a job specification, okay, you are normally put on probation. So this case is on probationary. Okay, normally probation period. How long do you think a probation period will be? Tempoh percubaan. How long it will be for an employee, a new employee? Yes, 3 months. Nurul Aina said 3 months. Okay, it can be 3 months, it can be 6 months or 4 months. Okay, so normally it's 6 months. Okay, and sometimes the employee is very happy with you, so he just put 3 months. Okay, so the maximum will be like 6 months. Okay, so the probation who is taken into permanent service, okay, should be advised of it by written notice served within 1 week of the completion of the probational period. Okay, let's say you are appointed as a probation first. Maybe you are junior HR officer. Okay, so you are given 3 months probation. So at the end of the probation, your employer should advise you by a written notice. Okay, so after you have completed, it's only within 1 week. Within 1 week, he must let know that you have been taken into permanent service. Okay, it's very important because if you're permanent staff, your benefit will be different from a probational employee. Okay, so let's say the employer does not want to confirm or do not want to terminate you. Okay, so according to Pari Perumal's case, you can read the case because it's about a clerk at the legal office. So he took the case against the lawyer. Okay, because he knows the law. Okay, so he took the case. Okay, so the court says that in his case, okay, since he was not given a letter, even though the a lawyer is the one who appointed him to be a clerk at his office, but no letter of appointment given to be a permanent staff, but the employer or the lawyer who appointed him give all the benefit that permanent staff is entitled. Okay, so he brought the case to the court. So the court says that he is a confirmed employee because he was not neither confirmed or terminated at the end of the probationary period. So the court says that he should be deemed to be a confirmed employee because sometimes the employee just give not all the benefit that belongs to a permanent service employee. He just give a few and he said that, okay, you are not confirmed. I don't want to give maybe the bonus or anything like that. So you should be given all that is entitled by a permanent staff. Okay. So you can understand. So when you are given a probationary period, so you should ask your employer what's your status at the end of the probationary period. Okay, don't just let your employer keep quiet without any confirmation letter because it's very important. Okay, because you will be entitled to get all the benefit that the other staff get, who is a permanent staff. Okay, can you get the point from the case? Okay, so if you read Pari Perumal's case, you can see what the court decide from the previous cases also. Okay, so the previous cases, the situation is different. Okay, so maybe you are put on placement, you are confirmed, and maybe you are doing very well at your workplace and you are being promoted. Okay, so what about promotion? Okay, Hotel Perdana's case says that Industrial Court has agreed that promotion is a managerial prerogative and it is for the employer to determine the criteria for promotion. Okay, let's say there's a few criteria. Okay, because normally for promotion, okay, you have to apply. Okay, and there will be few criteria that the employer will set. Okay, that's saying that you must serve the employer for 3 years. Okay, maybe your annual sale must be so much. Okay, or you can like bring new clients to the company. Okay, so there will be certain criteria. Okay, so the employer actually have the right to determine the criteria for promotion. Okay, so this is quite simple. Okay. Okay, so you can read not one case. What's the difference between upgrading, okay, and promotion? Okay, so this case actually explain on that, but you can skip this case because it's like a bit complicated. Okay, but promotion is where it's regarding a person. Okay, if you say promotion, so a person can be promoted if he is found in the performance of his duties and responsibility to be worthy of his higher grade. Okay, so his performance is very good. Okay, that the employer appreciate and wants to promote him. Okay. So we got other cases, Art Printing Works Sdn Bhd and Printing Industry Employees Union. In this case, the court says that it is not fair to ask an employee to act or perform work in a higher post without giving him an allowances. Okay, sometimes an employee at a higher post, let's say goes for study leave or maternity leave, and another employee have to take over. Okay, so if an employee is going to do that, okay, he must make sure that he pay an allowances. That means some extra money to the employee because he doing something that a higher post employee will be doing. Okay, any questions, students? Can you understand this case?
Yes, madam, understood.
Okay. Maybe someone else here? Okay, Nurul Masura says yes. Okay. Okay, so it's a bit easy, yes? You can understand. Okay, thank you for who have answered. Okay, then about promotion also. Rockmans of Paul Mall Berhad case says that an employee whose promotion is not confirmed should not lose his benefit when he is reverted to his old position. So all this is like we call it as principle, where is the important point that we can get from the case. Okay, so this principle is decided by the above case. Okay, so sometimes the employer says that you are promoted and we allow you 3 months. Okay, to show your performance. Okay, according to the grade that given and according to the salary given. Okay, so you within 3 months you must show your performance because you've been promoted. Okay, and at the end the employer is not happy with the you've been promoted, but he's not happy with the performance. Okay, you are just like before. Okay, you are not showing according to your promotion. Okay, according to the grade. Okay, so this case says that even though your promotion is not confirmed, okay, you should not lose your benefit when you are reverted to the old position. That means your promotion, you cannot be promoted because your performance is not good, so you will be reverted to the old position. So this case says that you should not lose the benefit. Okay, maybe you are given, let's say, 200 allowances because you will be promoted. Okay, the 200 that you get extra should not be reduced. Okay, so that's why it's very important for the employer. If you want to promote an employee, you study whether the employee can actually perform the job, the new job that will be given for the promotion. Okay, because you cannot reduce the salary after you already increase the salary. Okay, so beside promotion, okay, there are certain cases that you can be demoted. Okay, demoted means actually to go to the lesser grade. Okay, normally it's very difficult to demote a person. Okay, so but it can be in different form. You do not realize actually you've been demoted. Okay, how? So in this case, Wong Chi Hong's case, Wong Chi Hong versus KT organization, the industry indicate that some transfer are really demotion. Okay, so when you have not happy with an employee, okay, you demote an employee. Okay, so it can be in the way that you transfer the employee. Okay, you transfer the employee to another place. Okay, let's say, okay, now Wong Chi Hong, you have to in charge of another what do you call, another theatre. Okay, KT is a film theatre, you know that. Okay, you have to in charge of another theatre. Okay, in another state. It's actually a demotion. Okay, so in this case, the court says that it's not transfer but a demotion for Wong Chi Hong, and it's a punishment meted out without taking any disciplinary action. That means you punish a person without giving him any opportunity to defend himself. Okay, so in this case, it's actually a demotion. Okay, and it's not just like a usual transfer for an employee. Okay, so when an employee was transferred, you should consider yourself whether or you have to think about whether your employer really transfer you or he's making a punishment. He's giving a punishment to you. Okay, so you have to look at that point. Okay, so okay, So in real transfer, okay, in sometimes your company have subsidiary company or they open a new branch, okay, and you have to go for transfer. Okay, so Section 13 now allows an employer, okay, to transfer an employee, okay, and the industrial court actually vary the exercise of prerogative on transfer, okay. Um, in certain, that means in certain cases the court agree employee can be transferred. In certain cases the court says that you should not transfer an employee even though it's a manager prerogative. There's some limitation for that. Okay, so when can an employer transfer an employee? We look at the situation where it was explained in Guy's Misconduct of Employment. This is a textbook, okay, which explain the power of the employer to transfer an employee. Okay, so the author says that the power to transfer is subject to restriction. That means there's limitation to transfer an employee. Okay, so how? If there's nothing contrary to the terms of employment. Okay, so it's not stated. That means when you are appointed, okay, let's say as maybe as a legal assistant. Okay, so you have to check the appointment letter whether there's any clause on transfer or not. Okay, so it cannot be contrary or against the terms of employment. Okay, um, and the management has acted bona fide and in the interest of the business. That means if the employer want to transfer you, he actually doing something for the business, and he acted bona fide. He said, okay, you are a senior employee, you have some experience, you must go to the branch, the new branch, to help the employee there because you want to open a new branch. That means for the interest of the business, then it's a bona fide. It will be allowed under the law. Okay, and the management do not have any ulterior motive. Okay, you can relate number 2 to number 3, saying that he do not have any ill motive or bad intention why he want to transfer you. Okay, so this is 1, 2, 3. It's all actually interrelated. Okay, but it's put in different point. Okay. Number 4 is that the transfer is not made for the purpose of harassing or victimizing the workman. Okay, that means he's doing for the with good intention. He does not want to harass, or he do not want to victimize or want to punish the employee or the workman. So the employer do not have any intention on this. Okay, and the transfer actually cannot change the condition of workman. Okay, so this one can be related to number 1. Okay, so in the employment letter, there's no clause on transfer. Okay, or that it cannot change the terms of employment also. Okay, so if it's stated clearly that you will be working at this address, okay, so it's clear that you will be working at that particular place. Okay, so if you are given a transfer to another branch, okay, so that will be a change of condition. So you have to make sure that also. Okay, so the employer's right on transfer, okay, is subject to this all these 5 points or 5 limitation. Okay, so if you want to know whether the transfer actually change to the detriment of an employee in regard to the terms of employment, or transfer is bona fide, is actually a question of fact. So the court have to look whole story. What happened to the employee? Why the employer want to transfer? Okay, so you have to know the whole story to determine, okay, whether the employer have acted bona fide or not. Okay, so it's quite difficult. Okay, so the court will have to look at the whole story, okay, to determine whether the transfer is bona fide or not. Okay, so in case of transfer, sometimes you are transferred not within the organization, like to the subsidiary, to the branch, but it can be to another employer. Okay, so you can be transferred to another employer. Okay, so this is the old case, Philips Workers Union versus Philips Limited. The liability to be transferred from one to another by the employer is implied condition or service of every employee. It can be only taken away or curtailed or regulated in express term. Okay, so here whether an employee can be transferred or not. So it depends on the um, your agreement with your employer. Okay, so if there's any express term, you can be, but subject to other points like here in other case, Knox versus Doncaster Margaret. Okay, the employer here cannot actually sign the benefit of the contract of employment, the right of continuance of service of an employee to another without the consent of employee. Okay, even though the agreement, the employer is the one who prepare the agreement. He can prepare the agreement says the employee can be transferred to another employer, but actually the employer must also get the consent from the employee. Okay, so it's very important. Okay, the employer must get the consent of the employee. Okay. So any question on this matter?
No, madam.
No, madam.
Okay, so you understand. So suddenly if your employer says that, okay, you now must work with company A, so you must be very careful. Okay, the employer cannot transfer you unless you consent, because other things will come out now, or can raise, like in case you meet accident, or in case the new employer who take you do not want to pay your salary, who is going to take the responsibility? Okay, so it's very important that even though it's stated in the contract, the employee also must consent. Normally, an agreement must be signed between you, the employer that appoint you, and the new employer that wants to actually, we call that as borrow you, want to borrow you. Sometimes companies want to borrow from another company because they can see that you might be an expert, or maybe you have some knowledge that they cannot get an employee to appoint, so they want to borrow from another organization. It happens even in the government sector. Okay, like a new college open, or new university open, and they do not have any person expert in that particular field, they can borrow. Okay. Okay, so that case also says that no employee can be transferred from one employer to another, because an employee has always the right to choose his employer, and no one can compel, that means cannot force to serve another whom he does not like, because not every employer will like to work. That's why we want to choose when we normally when you want to get a job, you will choose whether you want to send the letter of a letter to apply for the job, company A or company B, because you want to know who is the employer. Okay, normally you have to study who is the employer first before you want to apply for job. Okay. Okay. So even though you are being transferred, sometimes another term being used. Okay, secondment. Okay, secondment. I think here secondment. Okay, transfer versus secondment. Okay. So what is the position when an employee who goes to the secondment from one company to another? Okay, so the here an author, O.P. Malhotra, says that therefore, so long as the contract is not terminated, okay, with the old employer, the new contract is not made also, and so the employee continues to be in the employment of the original employer. That means if the new or the one who took him to borrow him, okay, does not pay the salary, the original employer have to pay. In case of accident, the original employer also have to pay compensation. Okay. Okay, so uh, coming to next point, there will be retirement and resignation. So you have been appointed now. Okay, you might be on probation. If there's any um, chance for you to promote, you can be promoted or you can be transferred. Okay, now what about retirement? Okay, and resignation. So the industrial court differentiate the two definition. There's a Fung Kyong Rubber Factory Employees Union. If you want to know those days, when we go to school, we might be wearing either Bata shoe or Fung Kyong shoe. Okay, so this is a rubber factory that makes the shoe also. Okay. So this case says that retirement occurs on the happening of a natural event. That means you retire maybe at the age of 60, 55, like that. Retirement happening on the natural event, like age. Age is the retirement age, 55 or 60. Okay. Or illness, because of illness you cannot work anymore, or maybe because of death. Okay. And resignation is actually a voluntary act of the employee. That means you do it yourself. Okay, before you retire, you go and tender the letter of resignation. Okay, so that's the difference, retirement and resignation. Okay, so the same case is that in the absence of an express term, okay, contrary to the, like this case is in the collective agreement, a retirement gratuity is not payable on resignation. So if you resign, the employer will not give you any gratuity. There's any payment. They will not give you any payment because you resign. Some companies will give you, depending how long you have served the company. Maybe 20 years, okay, or even 30 years, okay, from the very young you work with the company and you want to resign, the company will give you some money, gratuity, okay. Okay, so when you want to resign, okay, you must do it with consent. That means you cannot be forced to resign or induced to resign. Okay, coercion is a force or duress. You cannot be forced or induced to resign. Okay, because it amounts to dismissal. Because resignation is from the employee itself. So if the employer want to force an employee to resign, that's not resignation, but it is dismissal. Okay, and Harper's Trading Sdn Bhd says that it's a well-established principle that industrial law that if it is proved that an employer offered the employee the alternatives of resign or be sacked and without anything more, that would constitute a dismissal. Okay, if the if the employer goes to an employee says that okay, if you do not want to resign, I will sack you. Okay, so that is actually not resignation but dismissal. Okay, that means you dismiss the employee. Okay, the employer dismiss an employee. Okay. So do you have any question so far?
No, madam.
No? Okay. Okay. So sometimes we have to terminate. Employee do not retire, do not resign, but you terminate. Okay, so we'll look at the law on termination now. Okay, so if employee terminate, that means he either resign or retire. Okay, this is the termination. That means your relationship with the employer comes to an end. Okay, if employer wants to terminate, it can be like surplus of labor, okay, or for poor performance, or maybe disciplinary action. Okay, so we got two act, Employment Act and also Industrial Relation Act. So the Employment Act actually focus on termination, okay, the notice period, all those, and the Industrial Relation Act provides machinery. Okay, machinery means what are the procedure if an employee has been dismissed, okay, what he should do. Okay, so the procedure is in the Industrial Relation Act. Okay, so we'll see at the notice period. Okay, how termination of contract can be made. Okay, Section 11 says that a contract service for a specified period, that means if you appoint an employee, let's say for 5 years, is 5 years, so it will terminate at the end of the period. Okay, so it's like that. Or you or you appoint an employee to do a piece of work, maybe to build maybe her house, or maybe to do something for you. Okay, and when the work complete, the contract also ends. Okay, so it can be for a period or a specific work to do. Okay, so what the employer should do is that under Section 12, the contract service may be terminated by one party giving notice to the other party of his intention to terminate. Okay, let's say you want to resign, you must also give a notice. Okay, so the notice must be in writing. Okay, and how you calculate the day on which the notice is given. Okay, so if you want to terminate, you must give a notice. The notice must be in writing. Okay, so how long notice? Okay, so the notice period for the employer and the employee is the same length. Okay, so unless you put in your own contract, okay, the notice period. If not, the notice period in the Employment Act will apply. Okay, so here, 4 weeks notice if the employee has been employed for less than 2 years. Okay, so if you work in a company for less than 2 years, you must give 4 weeks notice. The employee must give the employer 4 weeks notice. Okay, or if you work more than 2 years but less than 5 years, you must give 6 weeks notice. Or if you work more than 5 years, it will be 8 weeks notice. Okay, so it's very important. What happens if you don't give notice to your employer? You want to resign, but you do not want to give notice. What happened? What will happen? Arisa, what will happen? Any idea? Oh, you are not sure. Okay. Anyone else want to share experience working with with someone?
Doctor, it may be considered as absent if you don't give notice. Is that right?
No. What I'm asking is that you want to resign. Okay, let's say you work for 4 years. Okay, and you got a new job. Okay, the job is very good, and you like the job. The salary is high. Okay, and the new employer says that you must join the company next week. Okay, so what happened if you cannot give notice? You're supposed to give notice. If you look at this, if you work 4 years, and that means it is less than 5 years. Above 2 years, and less than 5 years because you work 4 years, your notice must be 6 weeks. Okay, 6 weeks. Okay, so you don't give notice to your employer, what will happen to you? Some say that you will not get salary for that month. Okay, can be considered. Okay, so you don't get salary, okay, for that month, but here the notice period is 6 weeks. Okay, so you will see what will happen. Okay, is there any no? Okay, let's see this section. Okay, the answer is here. Okay, a contract may be terminated by either party without notice, or if notice has been already given accordance to the section 12 without waiting for the expiry of that notice. So if you give notice, let's say you can only give notice for 1 week. Okay, but you're supposed to give notice for 2 weeks. 6 weeks in that case. Okay, where you work for 4 years. Okay, so you must pay, okay, by payment of indemnity to the other party. The other party here in your case will be your employer. Okay, equal sum that amount to wages, amount of wages which would have accrued to the employee during the period of such notice or during the unexpired period of notice. That means your notice is already short of 5 weeks because you're supposed to join the new company next week. Okay, so your notice is short of 5 weeks. Okay, so 4 weeks notice is equivalent to 1 month salary. Your notice will be equivalent to the amount of salary. Remember that. Okay, so if you work for 4 years, your notice supposed to be 6 weeks. Okay, now you can give only 1 week's notice. That means for 5 weeks notice you cannot give. So your salary will for that month will be deducted is only for 4 weeks. For another 1 week you have to pay your employer. Okay, so make sure that when you want to resign, you give notice according to the law. Okay, so if it is 8 weeks notice, then it will be 2 months salary. Okay, so you will not get the salary for that particular month, and again you have to pay your employer 1 month salary. 1 month is for 4 weeks notice. Okay, so can you get here the answer? What happened if you do not give notice to your employer? Can you? Can you get the answer, please, students?
Yes.
Bawazir, can you get? Bawazir Ahmad?
Yes, Doctor.
You understand, huh?
Can you give one more example on this?
Okay, one more example is that, okay, we take the, where's my slide here? 4 weeks notice, 4 weeks is easy, okay. Let's say you got a new job, you're supposed to join tomorrow. That means no notice can be given. We say that it's a 24 hours resignation. Okay, tomorrow the new employer says that you must come and join my company tomorrow. Okay, so you cannot give the notice at all to your present employer, because you will have a new employer. You're going to join the new company. Okay, so your 4 weeks notice is actually equivalent to 1 month salary. Okay, so you will not get salary for the particular month at all. If it is the end of the month, if not, you have to pay back 1 month salary to your previous employer. Okay, so it's very important for you to know how long you have worked with the company, okay, and how long notice you must give to your employer. Okay, so this is according to the Employment Act. But if your personal contract say that you must give 2 month notice, then you must give 2 month notice even though you work less than 2 years. Okay, so when you go to work, check on the length of notice in case you want to resign and you want to join another company. Okay, if not end of the month or end of the day that you want to join the new company, you will not get your salary. In fact, you have to pay your employer the amount of money which is equivalent to your salary. Okay, I hope that you can understand now. Okay. Okay, so other termination also notice must be given. Okay, so if this is for the employer, then now we see the example for the employee. In case the employer want to terminate you because he want to close down the business. Okay, where the employee has ceased or intend to cease business for the purpose for which the employees was employed, or he want to cease in the place. In the place means like in Malaysia or maybe in Thailand or in Indonesia, you want to close down the business there. So the employer also have to give a notice. Okay, there are few situation under section A 12, subsection 3A to F, where notice also must be given to the by the employer to the employee in different kind of situation under A to F. Okay, I explain two of the examples. I think the other examples you can read. Okay. Okay, so in case you want to resign or you want to terminate without giving any notice, now this section says that you must pay. Okay, by payment of indemnity. Indemnity is compensation to the other party. A sum equivalent to the amount of wages which would have accrued to the employee during the period. So how you calculate the compensation is according to the salary of the employee, the one that I give you an example just now. Okay. Then section 13 about termination says that a contract of service may be also terminated by either party without notice in the event of willful breach, okay, by the other party of an important terms or condition of employment. Okay, in case of very serious, very serious breach of contract, okay, both parties, the employer can terminate you and you can also terminate by giving notice to your employer. Okay. Uh, so there's a case for this also, even though it said a willful breach. Okay. In what situation? Okay. According to a case, it can be like the employee was absent for 3 days. Okay. So let's look at the facts of this case. Darul Aman Creation. Okay. Okay. Darul Aman's Recreation Center case. In this case, the claimant, the employee, the claimant is the person who make claim to the court. The claimant was chief chef at the company. He alleged that the company's managing told him through phone to stop reporting to work and to collect his salary. Okay. So the company contacted that the claimant did not report for 3 days, despite being informed to do so. Okay, so it was argued that claimant has self-terminated himself. Okay, so there was actually misunderstanding in this case. So the employee did not go to work 3 days. Okay, under section 13 subsection 2, the court says that the company had right to terminate the claimant, the employee, service as he had willfully breached the condition of his service contract when he stopped reporting to work. Okay, so it was concluded that the claimant has left the company's service on his own accord. Okay, so the employee did not go to work for 3 days, so he has self-terminated himself. So you can use section 13 subsection 3 where there was a willful breach by the employee. Okay, so here willful breach, even though the definition says that it must be something a serious conduct by either party, but in this case he did not go to work 3 days and he was a chief chef at the recreation center. That means his existence or his duty is very important at the center. He must be there to run the business of Darul Aman Creation Center. Okay. For other example, I think you try to get cases for section 13 subsection 2. Okay. So other special reason can be under section 14 of the Employment Act, okay, where an employer may dismiss also without notice an employee for misconduct inconsistent with the fulfillment of the express or implied term of condition. But this must be done after due inquiry or domestic inquiry. Okay, so an employer also can dismiss an employee under section 14. So you will see this topic under misconduct. Okay, that means if there's any misconduct done by the employer, an employee, okay, the employer can dismiss the employee without notice. May dismiss without notice. So misconduct can be, let's say he stole the employer's property, or he stole some cash at the company, or he have done any serious misconduct. Okay, so he can be terminated by the employer without any notice. But this must be done after due inquiry. So what is due inquiry? We'll look later. Okay, that's the right to be heard. The employee must be given the chance to be heard and for the hearing. Okay. Other situation where the employer have deemed to have broken his contract with the employee is when he fails to pay wages or salary according to the Employment Act. So if an employer do not pay salary end of the month, okay, but we see under the previous topic that he have 7 days to give the salary, and if you want extension, you can also apply to the Director General for extension, and he fails to pay salary, the employer is deemed to have broken the contract. Okay, so this is where section 50 subsection 1 applies. Okay, termination when the employer fail to pay salary. Okay, so the last, I think this is the last slide. Okay, regarding termination of contract by the employee. So the subsection 1 is by the employer, subsection 2 is by the employee. So section 15, subsection 2 says that the employee deemed to have broken his contract with the employer if he have continuously absent from work for more than 2 days. Okay, for more than 2 consecutive days without leave. That means he do not get any leave. What leave can apply here? Okay, annual leave. Okay, the other leave is rest day. You will be given. If you want annual leave, you have to apply. Okay, so no leave has been given by the employer, and okay, he have no excuse, no reasonable excuse. If he have a reasonable excuse, then this section does not apply. Okay, unless he has reasonable excuse for such absence, or unless he has informed or attempted to inform the employer of such excuse prior to or the earliest opportunity during the absence. Okay, so if you are absent for 3 days, you went to, let's say you went to Indonesia, okay, for holiday, okay, suddenly when you want to come back here, okay, there were some rules on COVID, you cannot come back. Okay, so you are absent for more than 2 days, and you must inform your employer. Okay, unless you fail to inform your employer, okay, or you have attempted to inform your employer, you are considered that you have broken the contract with your employer. Okay, so just you must try to inform your employer if you are absent from work. Okay, sometimes you might be somewhere else. Okay. Okay, any question? So you can understand section 15. This is very
Madam.
straightforward, section 15. Yes? Yes? Who wants to ask a
Understood,
question?
madam.
Yes? Yeah, Yi Chen. What's your question?
No. What I mean is I understood, madam.
Mm-hmm. Again? You understood? You can
Yes, I
understand what?
understood.
Okay, thank you. Okay. So someone here asked me, Kanisha asked me if the employer already worked for half month and want to stop work without notice. I've also have to pay full. Okay, only half month. He just joined the company. That means he's below. I think this is something that very. How are you going to? It depends, because according to the law, you're supposed to give 4 weeks notice. The employer can ask you to pay, but it's like you just work, okay, for half month. That means 2 weeks. Okay. So after working 2 weeks, you want to resign. But according to law, you have to pay the employer. You have to give notice. So how are you going to give notice? Okay. So it's something that before you work with your employer, actually you have to think whether you can work in such situation or not. Okay. But under the law, you still have to give notice. But this is something that is up to the employer actually. You just start work and you are not you cannot work with him. Maybe you and your employer, let's say the employee, and the employee is not in a good or understanding situation, then you want to resign immediately after joining the work. Okay, so it's I think you have to settle. Okay, but under the law, you still have to give 1 month notice. But you cannot give 1 month notice. You have to pay him the money actually. Okay. But if you go to the labour office, I think they will settle for you, asking the employer to give and take in this matter. Okay, Fidas asking, if the pekerja tak bagi notice, if the employee do not give notice and he was not paid for 1 month, okay, okay, actually here there's a 2 question. Okay, if the employee did not give notice, okay, of termination, okay, he's supposed to give. Depends on how long he worked with the employer. Okay, if he do not give notice, the employer can deduct his salary. Okay, that means the how, because the employee should pay compensation to the employer. How the employee wants to give compensation is the employer will deduct the salary. Okay, you don't have to give the compensation and then then you take the salary. Yes, it's not in a good way. So straight away the employer will deduct the salary or will not give the salary for the particular month because you do not give notice to him. So it will be in that way. Okay, but if the employee do not want to resign, okay, and the employer do not want to pay salary, okay, so you can complain to the labour department. Okay, that is different thing. Okay, so you put here together in one line, so it can be 2 different scenario. Okay. If no salary is paid, the employee can go and complain at the labor department. Okay. And if you want to resign, you must give notice. If you do not give notice, the employer can do not have to pay salary for the particular month, pending whether it's 4 weeks notice or 6 weeks notice or 8 weeks notice. If it is 4 weeks notice, 1 month salary. If 6 weeks notice, 1 month salary is not enough, you have to pay for the 2 weeks which the notice is not enough. If it is 8 weeks notice, you have to pay for the 4 weeks notice as 1 month salary to your employer. Okay, so a different situation. Okay, so Firdaus, I think, can understand Firdaus? Firdaus,
Madam, maksud saya, soalan saya,
yes.
contoh, saya hari ni saya dapat gaji, esoknya saya berhenti tanpa bagi notis. Jadinya majikan tak boleh deduct gaji saya kan?
Ya, kalau dah ambil notis baru nak henti, artinya you actually you do not want to go and report to your employer. Okay, there are different way actually. Okay, let's say you are an employee. Okay, this is actually not in a good industrial relationship lah. Okay, we say that it's not a good practice. Okay, today you got salary, you know that you want to resign. Okay, so you wait until you get the salary, and then tomorrow you do not want to go to work. Okay, that's what you want to do. If let's say you want to do that. Actually, it is not a good practice. If you want to resign, you should give notice. You must inform your employer. Okay, maybe after let's say 1 year or maybe next month, you meet your employer somewhere else. Okay, it's not a good way. If you want to resign, you're supposed to give notice. Okay, and if you do not go to work more than 2 days, your relationship with your employer also to be deemed to have been broken. Okay, when the contract deemed to be broken. So if you do not go to work more than 2 days, your relationship with your employer is also broken. Okay, that means you are not an employee to the particular employer. Okay, so the proper way is actually to give notice. Okay, but you give notice, you know that you will not be entitled for the salary. You must know that. Okay, some employers says no man, you don't have to give notice. It's okay lah. Okay, so it depends actually where you are working. Some employer really want to. Even the employer will do not know that if you don't give notice, he do not have to give your salary. Some employer do not know about that also. Okay, they think that okay, no mind, he give notice, he got a new job, he want to go away, no mind, I let him go away, no mind. Okay, some employer do not know that employee should give notice, and if they do not give notice, the employer do not have to pay salary. Okay, 1 month salary, the last month salary. Okay, many employers do not know that, and employers also have to deduct the what you call EPF for them. EPF, okay, the amount that due to the statutory body. They cannot pay the whole thing to the whole salary to the employee. Okay, Firdaus, I think after the class you can ask me also. Okay, so have you understood a prerogative of management so far? I think this is the last slide because I already divide the second part for the dismissal. Okay, any question? Students, do you have any question?
No, madam.
No, madam.
Okay. For this topic, we have another part, which is redundancy and retrenchment. Okay, I think we'll continue in next class together with dismissal. Okay. Okay, so any other question that you want to ask? Okay, so I think that's all for today's class. So next week you got your mid exam. Okay, remember, make sure that you answer the question, read properly the question and answer the question. Okay, do not copy paste from any notes. Right to please do it yourself. And you must make sure that if the question asks about case, give the full name of the case, facts, and also decision. Do not just put very little facts of the case. Okay, right. Properly on the facts and also decision of the case. Okay. And upload a PDF and upload on the portal. We'll give you instruction later next week when the question will come with the instruction. Yes, any question? Yes. Yeah. The soalan tapi 20 marks 20 marks for the question. Okay, so if we do not have any question, I think I will end the class today. Okay? Okay, students?
Okay, madam. Thank you, madam.
Okay, madam.
Thank you. Okay, thank you very much.